Also, joining us to discuss more on this is a legal practitioner, Festus Ogun. Hello, Festus. Thank you so much for joining us.
Thank you so much for having me.
Now, Festus, how does this ruling align with previous judicial decisions or constitutional interpretations, especially regarding the autonomy of local governments in Nigeria?
I would say without any fear of contradiction that this very judgment is a landmark decision that all Democrats and all progressives in Nigeria should celebrate. This is because the autonomy of local governments in Nigeria has been in siege for the past 2 decades, principally because he that bears the piper dictates the tune. In the recent past, we've seen how the state governments in Nigeria have been the one essentially dictating the financial state of the local government, despite the fact that these funds are being paid directly to the joint accounts operated by the state and local government. But we've seen that the local governments are not benefiting from the monies allocated by the federal government through the state government. So what the Supreme Court has said essentially is that now the state government can no longer sit upon the funds that are meant for the local government. And this has been the advocacy we've been doing over the years, that for us to have a progressive country, we must give room for fiscal federalism. And fiscal federalism begins essentially when state government begins to get the allocation that the federal government has sent to them.
All right, speaking of fiscal federalism, Festus, now what will happen to the LCDAs across the country when the Constitution recognizes only 774 local government areas where the funds are expected to go to? That's directly to, for example, in Lagos, the funds will be paid directly to 20 local government areas recognized by the Constitution. So what will be the fate of the other 37 LCDAs?
Local government development areas, LCDAs, are not known by the Constitution. What is known by the Constitution and what is created by the Constitution are local government areas. The numbers of local government areas created by the Constitution are 774. So the money that are to be allocated will be allocated directly to the local government areas that are created by the Constitution. Since the local government development area, the LCDAs, are created by the states. So the implication is that they are going to be funded by the states, because the money sent directly from the federal government of Nigeria to the local government areas created by the Constitution, the 774 local government created by the Constitution, are to be expended by the said local government. If the local government now goes ahead to allocate this money to the LCDAs, then it will be an abuse. But interestingly, these local government development areas, what we call local government development areas, are geographically and constitutionally subsumed under the local government areas. So one way or the other, the management of the affairs, of the local affairs of the LCDA will be subsumed under a particular local government. And when the resources from the federal government of Nigeria comes to this state, to this very local government, then the money allocated can cater for the LCDAs. Because looking at it, most of these LCDAs are carved out or created out of the existing local government areas created by the Constitution. So looking at it here or there, the allocated resources would still cater impliedly for the local government development areas, one way or the other.
All right, now, Festus, now the sad thing is that, despite the Supreme Court declaring it unconstitutional for state governors to hold on to these funds, some state governors, would still feel entitled to these funds, even after whatever ruling that comes out, in a bit. But what are the practical steps that state governments and local governments need to take to comply with the directive that local government allocations should be paid directly from the Federation account?
As far as the case before the Supreme Court is concerned, if the money allocated to the local government is tampered with by the state government, it constitutes a gross misconduct that would be a basis for the impeachment of an elected governor or deputy governor. It's a gross misconduct that would warrant the impeachment of the governor or deputy governor. So what I think should be done is for us, or is for the local government to be ready for what is to come. And that is not all. Again, the state government must brace up to accept this reality by putting in place the conduct of a free, fair, and credible election. Because part of the decision of the Supreme Court is that where the state government refuses or neglects to conduct a local government election, where democratically elected local government executive and councillors will be in place, then they will not be entitled to the allocations coming from the state government. So we need from the federal government. So what we need right now is a free, fair, and credible elections conducted by state government to put in place democratically elected local government executives. That is one. Again, I also feel strongly that state government should create anti-corruption agencies, because looking at the fact that we have 774 local government, the ICPC and the EFCC may not be able to adequately look at issues of corruption and malfeasance in this local government. So I feel that as recognized by the Constitution, there should be state anti-corruption agencies.
All right, now, Festus, just before we let you go, do you think that there are any legal mechanisms that the state governors can use to challenge or even resist the implementation of the Supreme Court's directive?
The Supreme Court has spoken. The governors are left with no other option than to accept the decision of the Supreme Court. It cannot be appealed against. Yes, they can apply for a review, but as it stands, the decision of the Supreme Court has to be obeyed with immediate effect. Any other action that is contrary to the clear decision of the Apex Court will not only be contemptuous, it will equally constitute a gross misconduct that will be a ground for the impeachment of the governors. Let me say this before we conclude, that as a country practicing a constitutional democracy, we cannot afford to disrespect the clear ruling of the Apex Court. Anything outside respecting the court orders, especially from the Apex Court, which is not just a court of law, but also a court of policy, would, throw our country into a banana republic. The governors are left with no option than to obey the decision of the Supreme Court, not just in the interest of the state, but equally in the interest of the local government. Fiscal federalism is what we've been advocating for. In the absence of fiscal federalism, the essence of federalism, in fact, the essence of our democracy is completely defeated. So I feel that it's a great decision. It's a landmark decision. We must commend the government, the federal government of Nigeria. We must commend the Honorable Attorney General of the Federation. And as a people, we must be ready for the breath of fresh air that we've received as a people. And we must keep our eyes very open, vigilantly, on the local government executive when the funds start rolling indirectly.
All right, well, thank you so much, Festus, for taking time out to speak to us on this.
Thank you for having me. Thank you for having me.